Question 981. The duties of an industrial property manager likely do not include the following. A. Verifying the operation of the fire alarm system. B. Composing the lease agreements. C. Hiring security guards. D. Maintaining the building's landscaping. Correct answer is B. Composing the lease agreements. An industrial property manager is involved in the leasing process, showing the property, negotiating terms, etc. The composition or drafting of the actual lease agreements is typically handled by legal counsel, lawyers. The property manager might use standard lease forms and fill in the blanks, but they generally don't create entirely new lease documents from scratch due to the legal complexities involved. The other options are common duties of an industrial property manager. A. Verifying the operation of the fire alarm system. This is part of ensuring safety and compliance with building codes. C. Hiring security guards. Security is a major concern for industrial properties, so managing security personnel is a common responsibility. D. Maintaining the building's landscaping. Maintaining the grounds is part of overall property maintenance. Question 982. Which of the following is not an example of voluntary alienation of property? A. Gift. B. Will. C. Sale. D. Forfeiture. Correct answer is D. Forfeiture. Voluntary alienation means the transfer of property is done willingly by the owner. Forfeiture, on the other hand, is an involuntary transfer of property. It occurs when an owner loses their property due to a breach of a condition in a contract, like the land contract, or due to legal action, like condemnation or tax foreclosure. The owner does not willingly transfer the property, it is taken from them due to their actions or legal proceedings. Question 983. The types of consent that can be given are A. Express. B. Statutory. C. Implied. D. Both A and C. Correct answer is D. Both A and C. Express consent is consent that is clearly and explicitly stated, either verbally or in writing. For example, signing a contract or verbally agreeing to a service. Implied consent is consent that is not explicitly stated but is inferred from a person's actions or the circumstances. For example, if someone sits in a barber's chair, it's implied that they consent to a haircut. Statutory consent isn't a recognized form of consent in the same way express and implied are. Statutes, laws, may require consent for certain actions, but the consent itself is either express or implied. For example, a law might require express consent for medical procedures, but the consent itself is still express, a signed form. Therefore, while statutes can govern consent, they don't define a type of consent. Question 984. A franchise may be sold by A. Real estate licensee. B. Securities licensee. C. Person registered for that purchase with the California Corporations Commissioner. D. Any of the above. Correct answer is D. Any of the above. The sale of a franchise can involve different types of licenses or registrations depending on the specific nature of the transaction and the jurisdiction. A real estate broker's license in California authorizes the sale of business opportunities. A franchise is often considered a type of business opportunity, especially if it involves the transfer of an existing business with goodwill, assets, or real property. Therefore, a real estate licensee can sell a franchise under this authorization. Generally, the sale of a typical franchise is not considered the sale of a security. In most cases, a typical franchise agreement isn't considered a security. However, it could be deemed one under rare and specific circumstances. This occurs if the agreement is structured so the franchisee is a passive investor, relying entirely on the efforts of the franchisor or other parties. In such a case, a securities license would be required. This is uncommon for most standard franchises. The California Franchise Investment Law regulates the offer and sale of franchises in the state. This law is administered by the California Department of Financial Protection and Innovation, DFPI, which was previously known as the Department of Corporations and is often referred to by that historical name in some materials. Franchisors must register their offers, and individuals or entities acting as franchise sellers or franchise brokers. This registration is specifically for selling franchises. Therefore, the most comprehensive answer is D, any of the above. Question 985. An EER measures a property's A. Electricity effectiveness rate, B. Energy efficiency ratio, C. Escalating energy report, D. None of the above. Correct answer is B. Energy efficiency ratio. EER stands for Energy Efficiency Ratio. It's a measure of the cooling efficiency of an air conditioner or heat pump. It's calculated by dividing the cooling output, in BTUs, by the power input, in watts. A higher EER indicates greater energy efficiency. Question 986. For a lease to be properly recorded, the lease agreement must be acknowledged by the A. Lessor, B. Lessee, C. Attorney for the lessee, D. Escrow officer. Correct answer is A. Lessor. To answer this question, we need to understand the purpose of acknowledgement in real estate documents, especially for recording. For a document to be recorded in public records, like at the county recorder's office, it typically needs to be acknowledged. Acknowledgement is a formal declaration before a notary public or other authorized officer by the person who signed the document, stating that they signed it voluntarily and for the purposes stated therein. The primary purpose of recording is to give public notice of an interest in real property. A lease conveys an interest in real property from the lessor, landlord, to the lessee, tenant. The act of leasing burdens the lessor's fee simple interest with a leasehold estate. For a lease to be publicly recorded, the signature of the party conveying or encumbering the property interest must be authenticated. This provides constructive notice to future owners, while the lessee also signs the lease to agree to its terms. Their signature generally does not need to be acknowledged for the purpose of recording the document itself, as they are the party receiving the interest, not conveying or encumbering the fee simple title. An attorney might prepare the document, but the party themselves, or an authorized agent with power of attorney, must acknowledge their signature. An escrow officer facilitates the transaction but does not typically acknowledge signatures, a notary public does. Therefore, for a lease to be properly recorded, it must be acknowledged by the lessor. Question 987. When a leased property is sold, any leases with existing tenants are A. Automatically terminated, B. Breached by constructive eviction, C. Binding on the new owner, D. The leases are renegotiated by the new landlord and tenants. Correct answer is C. Binding on the new owner. When a leased property is sold, the general rule in real estate law is that existing, valid leases remain in effect. The new owner steps into the shoes of the previous landlord. A lease creates a legal interest in the property. When the property is sold, the new owner typically takes title subject to any existing encumbrances, including active leases. The new owner becomes the successor in interest to the original landlord. They inherit the rights and obligations under the lease agreement. This means they must honor the terms of the existing leases, collect rent, and provide the services agreed upon, until the lease terms expire. Tenants generally have the right to continue occupying the property under the terms of their original lease, even if the ownership changes. Leases are contracts and are not automatically terminated by a sale unless a specific clause in the lease allows for it, which is rare in standard leases. A sale of the property itself does not constitute constructive eviction. Constructive eviction occurs when the landlord's actions make the property uninhabitable or unsuitable, forcing the tenant to leave. While new landlords and tenants can choose to renegotiate, they are not obligated to do so. The existing lease terms remain legally binding. Question 988. The Smiths are anxious to buy a new home that just came on the market, but they haven't yet succeeded in selling their current home to pay for the new one. Which kind of loan would they probably not want to obtain? A. Swing loan. B. Conventional loan. C. Gap loan. D. Bridge loan. Correct answer is B. Conventional loan. Swing loan, also known as a bridge loan or gap loan, is a short-term loan that bridges the gap between the purchase of a new home and the sale of an existing one. It allows buyers to purchase a new home before selling their current one, using the equity in their current home as collateral. A conventional loan is a mortgage loan that is not backed by a government agency such as the FHA, Federal Housing Administration, or the VA, Department of Veterans Affairs. Conventional loans typically require a larger down payment and have stricter qualifying requirements than government-backed loans. Since the Smiths haven't sold their current home, they likely don't have the cash for a large down payment. A conventional loan is a less desirable option. Question 989. If an agent refers a client to an in-house lender, she must their affiliated business relationship. A. Disclose that affiliated business relationship. B. Ask the in-house lender for a bonus for the referral. C. Both A and B. An agent can make no such referral to an in-house lender, because it would be a conflict of interest. Correct answer is A. Disclose that affiliated business relationship. If a real estate agent directs a client to an in-house lender, a legal obligation arises. This is because the lender shares an ownership or financial interest with the agent's brokerage or related entity. Such referrals are governed by the Real Estate Settlement Procedures Act, RESPA. RESPA allows for such affiliated business arrangements, but it requires that the agent disclose that affiliated business relationship. This disclosure must be in writing and provided to the client at or before the time of the referral. It must inform the client of the nature of the relationship. They are not required to use the affiliated service provider, and provide an estimate of the charges. This disclosure allows the client to make an informed decision about whether or not to use the referred service. Question 990. According to the Truth in Lending Act, TILA, it is not necessary to disclose the finance charges for a loan involving A. One business buying up the inventory of its failing competitor. B. Remodeling a living room. C. Buying grain to plant crops. D. Both A and C. Correct answer is D. Both A and C. The Truth in Lending Act, TILA, primarily applies to consumer credit transactions. It's designed to protect individuals in personal, family, or household credit situations. TILA generally does not apply to credit extended for business, commercial, or agricultural purposes, regardless of the amount. Remodeling a living room is a consumer transaction for a personal residence, so TILA would require disclosure of finance charges.